Professor Facer pointed out, the traditional debate about the Second Amendment has been over whether it is an individual right or some other manner of provision. The other matter started out as the collective right theory, which was a right of the states. Well, that didn't get very far, because the simple text of the Constitution it speaks of the right of the people to keep and bear arms, and the people throughout the Bill of Rights is used to refer to people, not states. The right of the people to peaceably assemble, the right of the people against unreasonable search and seizure, and so on. So the collective right itself didn't last very long. It transmuted to the sophisticated collective right, which is that it's a right of the individual to belong to a well-regulated militia, which conveniently does not exist at the moment. And from there, it mutated into a sort of, is the Second Amendment militia-centric? I'll talk in the last term. Is the Second Amendment an individual right, or is it somehow militia-centric? That's been the traditional debate. I suggest it's completely incorrect. That is not the choice. We're not presented with a binary choice between one or the other. Both approaches, I think, are correct to the extent they speak about a purpose of the Second Amendment, and both are wrong to the extent they speak about the purpose of the Second Amendment. The Second Amendment, after all, has two clauses. The reason it has two clauses, I would suggest, is because it had two purposes. It meant to appeal to two different bodies of the framing generation, both of whom were skeptical about the new Constitution. And the Bill of Rights is sort of exceptional in one particular aspect, which is that it was drafted and adopted by Federalists in order to please the anti-Federalists, to get rid of the critics of the Constitution. If you weren't, in fact, going to establish a religion, you weren't, in fact, going to suppress freedom of speech, at least for a few years until the Alien and Sedition Acts came along, then why not just eliminate the criticism by saying, we won't do this. We'll give you a guarantee. We will not do this in the new government. We never planned to. It costs us nothing to swear off what we never planned to do. You've got to understand that there were two principal influences on the framers. One was the classical Republican movement, which essentially focused on the structure of government. It starts out with, curiously enough, Machiavelli in the Renaissance. Machiavelli, before he became more experienced in the world and more cynical, started out speaking in terms of creating a republic. And one of the problems he faced, being at least a realist, if not yet a cynic, was how do you defend this republic? He posed a dilemma, which is, at that point in Italy, the city-states were fighting using using professional armies, which weren't particularly effective and weren't particularly costly. Well, he pointed out, if you have a formal professional force that is powerful enough to protect you against aggressors, it's also powerful enough to take over. And he composed predominantly of young men without property. Why should they be satisfied with the salary and benefits when they can have the whole thing? Why should they take orders when they can give orders? His solution to it was a militia organization. Eventually, the movement came into English law via John Harrington, I think, in the 17th century. And in the English form, it took this aspect. We'll take a triangular relationship and base the state on that. The triangular relationship will be, first of all, landowners, because at that point that was the only form of wealth that was recognized. Secondly, the landowners will be given the vote. Therefore, the landowners, the property owners will have all the political power. Third, they will be required to serve in the militia and provide a military force. Now the militia can be infinitely powerful and you don't have to worry about it. They can't take over in order to seize political power because they already have it. They can't take over to seize property. They already have that too. So you have created a stable system. That prevailed in the early colonies. It was especially strong in Virginia. But alongside it came what was at the time called the radical movement. Today would be referred to as Jeffersonianism, Jeffersonian Jacksonianism, something like that, which took a much more broad view of individual rights, much more individualistic, and in particular, much more favorable to creating bills of rights. If you were a classical Republican, bills of rights didn't matter. They're mere parchment barriers. If you created a stable system, it would continue to exist and protect individual rights. If you didn't, it was, what good was a mere parchment barrier, as I think Madison put it. Now, I'm not saying that all people fell into one category or the other. Lots of them were somewhere along the continuum between the two ideas. George Mason, for example, was a strong classical Republican. He was also the most powerful push for the Bill of Rights. People are, as one man has put it, we're not logical creatures, we're psychological creatures. So, anyway, now we have a classic illustration of this in Virginia, 1776. The colony has now declared it's a separate state. It's no longer simply a British colony. Well, you're going to need a constitution now. And Thomas Jefferson put up one proposal. I mean, his proposal was very much individualistic. There's no way to read that as this is concerned with the militia, or exclusively the militia. The Virginia legislature didn't go with that. Instead, they went with a rival proposal drafted by George Mason, who was coincidentally a colonel in the Virginia militia. Now, tell me that those two statements are the same thing. That one man is rewording the words of the other. No, they're talking about two totally different ideas. Jefferson's talking about an individual right. Mason is talking about the militia as a system. And the problem with the conventional debate is you have to assume that these were not two separate ideas, and the Second Amendment's two clauses were not two separate ideas. That the most articulate people of the most articulate period of our republic were so inept at phrasing things that when they wanted to guarantee a well-regulated militia, they said no free man shall be debarred the use of arms, and when we wanted to protect an individual right, they wrote about a well-regulated militia composed of the body of the people trained to arms, etc. No, they were talking about two different things. Now, Pennsylvania in 1776, a few months after Virginia, gives us another example. Pennsylvania was an interesting case because what happened was the legislature tended to be stacked against declaring independence. It was controlled by the Quakers and various German groups which were very much pacifistic, didn't want to get into a fight, and that sort of thing. So they did what was the radical, whatever you call patriots, did what was natural under the circumstances. They purged them. They created a new constitution, managed to ram it through, which required you to swear, not swear, allegiance to the new country, which meant all the Quakers were deprived of the vote. And this new radical regime created their own version of what a future right to bear arms. Again, compare the two. The people have the right to bear arms for the defense of themselves and the state, compared to Virginia, well-regulated militia. They're really two different groups with two different political outlooks, creating two different sets of words. Now, there were later proposals also of various bills of rights. There was a Pennsylvania minority. Yeah, the Pennsylvania minority, the reason the minority is the people who purged got back into power before we come up to ratification of the U.S. Constitution. 12 years had passed, and now the radical element was in the minority. They talk about people having the right to keep their arms for the defense of themselves or their own state or the United States, and even for the purpose of killing game. These guys want to go deer hunting and have it as a constitutional right. In Massachusetts, Sam Adams, not the radical one, not John Adams' cousin, he wanted one that was equally individualistic, talking about the Congress shall never prohibit people from keeping their own arms. New Hampshire ratified convention, critical convention, because it gave the Constitution the 9th vote that meant there would be a Constitution of the United States, at least as to the states that had already signed on. And that one, the New Hampshire people specified Congress shall never disarm any citizen, except such as those who have been in actual rebellion. Again, we're not talking about the militia. At the point when you had the federal ratifying convention ratifying the new Constitution, they're talking entirely about an individual right to arms. This would suggest that the two clauses of the Second Amendment, militia, arms, the arms clause at 1788, 1789 was the more significant to most people. Now, we're at that point, the Constitution had already been ratified. We're at the 11th hour of constitutional history. Virginia has its convention. The question is whether Virginia at that point, I think it was the largest of the states, would join in the new federation. Virginia settles down and they draft their own demand for a federal Bill of Rights. And for the first time, it occurs to the framers, you guys want a militia guarantee. You guys want an individual right guarantee. They're not inconsistent. Why don't we just do them both and please everybody? And so you have the Virginia proposal, direct ancestor of the Second Amendment. We'll do it well. We'll lay it out and, there was, the people have the right to keep their arms, and a well-regulated militia is essential. So please everybody. Please Mason, please Jefferson, keep everyone happy. Now, in the first Congress met, James Madison became the principal sponsor of the Bill of Rights. And if you read the debates, it's sort of interesting because human beings haven't changed in the last 200 years. At one point, the first Congress has spent days debating the topic of, do we really have enough time to draft a Bill of Rights? And Madison gets up in frustration and says, essentially, if you just draft this dang thing, instead of debating if we have enough time to draft the dang thing, we have it together already. Anyone who's been through a committee meeting can understand that. So basically what he does is he takes the Virginia proposal and reverses the order of the two clauses. It keeps them on a fairly long militia clause, puts in a conscientious objector clause, and has his proposal for a Bill of Rights, what became the Second Amendment. Started out as the Fourth Amendment. There's all the problem that Justice Douglas has stated the First Amendment is the first for a reason. Actually, it started out as the third. Now, one interesting thing is that in the first Senate, there was a proposal, and since we only have the journal of the Senate, we don't have anything like a transcript, we don't know who made it. But the proposal was to insert the words for the common defense. The people have the right to keep and bear arms for the common defense. What the journal simply says it passed in the negative, meaning it got voted down. Somebody wanted to link the two clauses back together more firmly, make them both militia-oriented, it got voted down. Now, the odds of two clauses that said the same thing surviving was very low. The first Congress was a brutal editor of Madison's proposals. I mean, they really gave them a working over. The First Amendment, for example, Madison's version, 3 sentences and 107 words long. When it got through the first Congress, was 1 sentence and 45 words. The First Amendment gives us a model because in it, you had protected in one amendment, not one right or two rights, but depending on how you want to count freedom of assembly, either 5 or 6 rights. They're generally the same thing. They're dealing with matters of intellect, of feeling, religion, speech, that sort of thing. And I think the Second Amendment did the same thing, which was take two rights that people really want and attach them together. What you find from the history going on from that point is, curiously enough, the idea of the universal militia really faded out. It's probably significant that you got to Virginia in terms of ratifying conventions, the 10th ratification, before anybody decided to try to put that in the draft Bill of Rights. What was happening was largely logistic. In Federalist 46, I think it is, James Madison talks about how the country can have a militia of 500,000 men. Well, you got to feed them somehow. most of the Revolutionary War battles in the South involved about 1,000 to 1,500 men on each side. The big battles up in the North involved maybe 10 or 20,000 on each side. Standard rations for the time were 3 pounds of food per day per man. You've got 600 or 500,000 people. That means you have to be able to move 1.5 billion pounds of food to wherever they are per day, using nothing but wagons on small rutted roads, because nobody's come along with steamships or the railroads yet. So the bottom line was you were never going to need or have the ability to feed 500,000 men as an army. What you needed was much smaller forces. And from the early 1800s onward, what they did was the federal 1792 Militia Act said the states could exempt anybody they wanted. So they exempted everybody. At the start, they required you to pay a tax to buy equipment for a volunteer militia, that sort of thing. So basically, by the time you get to the Civil War, the universal militia is dead. The right to bear arms is still living, as Steve pointed out in the 39th Congress, the 14th Amendment, all that was very much lively. But the idea of the militia as a universal force was kaput. Now, I think this understanding played a role in Heller. Steve mentioned when Justice Kennedy came out and gave the oral argument. A few moments, maybe 30 seconds before that, Kennedy said something else, and I realized, I think we just won. Kennedy, it seems to me that there is an interpretation of the Second Amendment differing from that of the District Court and in Miller, and not advanced particularly in the red brief, which was Heller's brief, but that confirms the two clauses and in fact delinks them. The first clause, I submit, can be read consistently with the purpose I've indicated of simply affirming the existence and importance of the militia clauses. Those were two very important clauses. And so in effect, the amendment says we affirm the right to have the militia, we've established it, but in addition, there's a right to bear arms. Can you comment on that? And the DC advocate gave some sort of answer, I forget what it was exactly, I think he missed the point. But then Scalia came in and sort of relinked them, although much more clumsily. Scalia, I don't see how there's any contradiction between reading the second clause as a personal guarantee and reading the first one as assuring the existence of the militia. In the opinion, he gave an explanation that was essentially the right to keep bear arms is the relevant clause, and the militia clause is the prefatory clause that gave the reason why the right to keep arms was important enough to be written into the Constitution. Interesting theory, there's no historical evidence for it. I think it started out and ended up as two individual clauses. What's the logical significance of this? Well, the debate between the individual right and the collective something or other has never been focused upon having someone actually saying that. If you search the record, none of the framers said, we do not intend to create a right to bear arms. None of the framers said, back with the militia. What they all said was, we want this or we want that. And the only way we get from that to this debate between two ideas, only one of which can be true, is by assuming that the amendment could only have had a single purpose. So if you could prove George Mason was talking about the militia, that proves it doesn't concern an individual right. But if in fact it had two separate purposes, as meant to appease both the classical Republicans and the radicals, then that's not true. It has two separate purposes, and we can only assess the right to arms clause by reference to the rights to arms clause. Anyway, this is a theory I've long had. I hate to admit it, given my age, but I advanced first in 1986. And it explains, it is a more scientific approach in the sense of what are you looking for in scientific theory? Something that explains all known facts and is inconsistent with none of them. This passes that test. It explains all known facts, explains why Jefferson wanted the right to keep and bear arms,
And when Mason wanted the protection of the militia, it's inconsistent with Gunnersville. We only today think it had to be one or the other, so that if you talk about the militia, you couldn't possibly, somebody else couldn't possibly want the right to bear arms, because we've lost that fundamental understanding which the framers had. It was so obvious to them, they didn't need to put it out, didn't need to express it correctly. We're talking about two different things. Just as under the First Amendment, we're talking about 5 or 6 different things. There's nothing wrong with that. We're trying to please everybody. There's 2 different groups here. We'll please them both. Thank you.